Rules Committee, come to order, and thank you very much for joining us today. As we begin, I'd like to take a moment to recognize what Mrs. Slaughter and I were just speaking about, and that is the terrible attack that took place last week at Marjorie Stoneman Douglas High School in Florida. I know this shooting has affected all of us in a profound way, and I'd like for us to take a moment of silence, please. Thank you. We should remember that this has affected us, each of us, not only our wives, but our children, our communities. It's shaken us to the core, not only of institutions that represent us, but also this institution, and this institution will respond. I think we all need to do our part to address school safety, and I have done that back in Dallas, Texas, and have come with a plan, if anybody's interested in seeing it, about what my plan is. I'm very open to sharing that with any of the members that are here. I'm sure if they give me their plans, their ideas, we can work together to make sure that we try and make this country an even safer place on our campuses. Today, the committee will be considering H.R. 1865, the Allow States and Victims to Fight Online Sex Trafficking Act of 2017, H.R. 4296, to place requirements on operational risk capital requirements for banking organizations established by appropriate federal banking agency, and H.R. 4607, the Comprehensive Regulatory Review Act. H.R. 1865 creates a new federal statute with increased penalties for promoting sex trafficking online and amends Section 230 of the Communications Decency Act to permit local and state criminal prosecutions of bad actor websites, in granting federal, state, and local law enforcement more practical tools to hold bad actor websites accountable. This bill provides protections and justice for the children and victims who have been taken advantage of by online sex trafficking. The committee also will consider H.R. 4607, legislation that amends the Economic Growth and Regulatory Paperwork Reduction Act of 1996 to ensure the federal financial regulators perform a comprehensive review of regulations to identify outdated or otherwise unnecessary regulatory requirements imposed on covered persons. The explosive growth of bank regulations following the enactment of Dodd-Frank has made significantly harder for community banks and credit unions to serve their customers. And I believe it only makes sense that regulators should have to review their regulations on a consistent basis. So the final bill under consideration today will be H.R. 4296, that does not eliminate operational risk capital requirements, but does ensure that we look forward-looking and appropriately tailored a bank and their current risk portfolio. The complexity and backward-looking nature of current operational risk capital requirements are leading to unintended consequences, namely a diminished consumer credit market. H.R. 4296 ensures that existing capital standards are appropriately tailored and are not needlessly looked up capital, but otherwise would be used to provide loans to consumers and small businesses. In other words, we're going to quit looking back at where we are and where we are currently and moving forward. So without objection, I would like to welcome the gentleman from Pennsylvania, Congressman Marino, and the gentlewoman from Missouri, who I'm delighted that Ms. Wagner is here, the author of H.R. 1865. And I also recognize the gentlewoman from Texas, Ms. Sheila Jackson-Lee. Welcome to the Rules Committee, to this first panel, and thank all of you for being here, for not only your expert witness ability, but also providing us confidential or great information about how your party might look at this and the effect on your congressional district. And I want to welcome each of you. Before we go any further, I want to make sure that I say that without objection, anything you brought in writing, we're going to be on the record, and would yield to the gentlewoman, the ranking member of the committee, Ms. Slaughter, for any statements she'd like to make. Gentlewoman's recognized.
I thank you, Mr. Chairman, very much for letting me do this. I appreciate the importance of this bill, and I'm delighted that we're doing it today because it has great importance. But I, too, need to say something about the carnage and about the killing of America's children. On February 14th, last week, a gunman set off a fire alarm and opened fire on his former classmates at the Marjorie Stoneham Douglas High School. We've spoken up here so many times about mass shootings after mass shooting after mass shooting in our churches, movie theaters, and even, most especially, our schools. An 18-month-old baby was killed in the Texas shooting. We lost 20 children in Newtown, 6 adults, 17 killed in Florida, including teenagers. 58 people were killed in Las Vegas. That one man responsible for Las Vegas was able to kill 58 people and injure 851 in about 10 minutes. Think about that for a second, would you? And think about, I appreciate Second Amendment rights, but where are ours? Do we have a right to go to something we'd like to enjoy, a concert, a theater, to go to church with our fellow parishioners and go back home? Surely to goodness we have to do it. When are we going to do something about it? Shooting deaths happen so frequently that we don't even acknowledge most of them. Look at how quickly the attention on the shooting in Las Vegas evaporated. All we hear from our leaders is too soon to talk about it. It makes it political or something, so we can't talk about that, but we will give thoughts and prayers. I realized about a year ago how hypocritical that was. That standing there, sending good thoughts and prayers to people that we could have helped to prevent the loss that they were suffering from, that we were trying to relieve them of the burden, didn't make a lot of sense to me. It's not too soon to talk about solutions. It's too soon for the 17 we lost in Florida and thousands of people who died at the hands of a gunman, and it is too late for the families who have been left behind to mourn their losses, but not too late to work together to stop these tragic murders. I said this after the Sutherland Springs shooting, but I think it's worth repeating. It doesn't have to be this way. Why don't we require verified background checks for all gun sales? Why do we let people that we know have mental illness buy guns? Why do we not lift the ban on the Communicable Disease Center to be able to research gun violence? That's one of the things that the NRA has given us, that they may not research that. Also, as part of the health care bill, you may not know it, but no doctor in the United States can ask a patient about guns in the home. They can ask about drugs. They can ask about many other things, but guns they may not talk about. And in Florida, I understand that you can be fined as much as $5,000, I believe, if you mistakenly ask somebody about guns when you shouldn't. We research vehicle fatalities, and we try to find ways to reduce those. We require manufacturers to create safer cars, and we prohibit people from driving while impaired or distracted. We prohibit speeding. These policies save lives. But it's as if we're not even allowed to talk about gun deaths in the Congress of the United States. For some reason, it's just never the right time. Over 500 people are unintentionally killed by guns every year. So we could solve that by making gun manufacturers make guns that don't go off if they're accidentally dropped. Why don't we require new guns can't fire when a magazine is removed, whether or not there's a bullet in the chamber, in order to reduce those accidental deaths? Why don't we require the manufacturers to make guns that produce bullets traceable, not only to the make and model of the gun, but to the exact gun? That would increase the threat of being caught when committing a gun crime and maybe deter some would-be criminals. How simple that would be, but we don't want to do that either. Why don't we work towards technology that allows guns to only work in the hands of the rightful owner so that stolen guns become useless? Why don't we direct law enforcement to at least check in on people who buy excessive amounts of guns or ammunition? Because we're not allowed to. Why do we let people with a history of domestic violence have access to guns? Because we're not allowed to stop them. Why do we let people who are part of the terrorism watch list buy guns? Because we can't stop them. The man charged in the Florida shooting was reportedly visited by police dozens of times. I think I read the other day that there were 23 calls about him by people who knew him well to the sheriff's department, and nothing was done, nothing. Why don't we have a select committee on gun violence in the United States Congress? And for the love of God, why have we not yet banned bump stocks and devices like them that could be used in another Vegas-style attack? We spend week after week debating bills on regulations that virtually no one has heard of, each week attacking Dodd-Frank. Well, if that's your priority, fine. Find time to do it. But our citizens are not dying by the thousands because of Dodd-Frank. They're being killed by guns, by people committing crimes, by people with mental illness, through suicides, through guns going off by accident. And the worst of all, they're being killed by weapons of war that have absolutely no right in the hands of civilians. When are we going to take up legislation to do anything about the gun violence epidemic in this country? They're killing our children. Thank you, Mr. Chair.
Thank you very much, Louise.
Mr. Chairman?
Yes, sir.
Mr. Chairman, I'd be very remiss if I
Gentleman's recognized.
Make comments. First off, I echo all of the sentiments expressed by the ranking member, my good friend, Ms. Slaughter. Later this week, a preeminent Christian and evangelical will lie in state here at the Capitol. And rightly, we are able to prioritize matters or to demonstrate our commitment to the kind of leadership that the Reverend Billy Graham exemplified throughout his extraordinary career. I take from your remarks initially, Mr. Chairman, just one statement that gives me some hope. You did say, after your expressions, that this, and I'm quoting you, this institution will respond. I can't tell you, not from you, Mr. Chairman, but over the years, how many times I've heard comments along the same line. The state of Florida, in 2011, its legislature issued a measure preempting cities and counties in the state of Florida from passing any measure having to do with gun laws. In addition, they made it a liability if a sitting city or county official or other official attempts to do so, carrying with it a $100,000 cap on the liability and removal from office. I can't imagine a group of people who feel so strongly about states' rights would then take away from the folk who are more likely to be able to know what's going on in their respective communities their rights. I think it's unconstitutional. I don't believe it has been tested. I know there's a case out of Illinois that went to the Supreme Court on the same subject, and the court refused to take it, allowing the city of Highland Park in Illinois to go forward with their measure. I agonize with all of us when it comes to this discussion. But my hope this time is that we will have an intelligent discussion. There are things that we can and should do that will help avert these kinds of tragedies. But I want to speak personally. When you called for a moment of silence, I did not bow my head. And the last 5 times, dating after Sandy Hook, when we've had moments of silence on the floor of the House. I understand that dynamic, and it is a good show of the concerns of this institution. But then we turn and go right back to business as usual. So since Sandy Hook, I've not stood anymore for moments of silence when I know that we are going to return to the exact same posture that we have manifested throughout the years. That's very troubling. So today I'm challenged because the shooting in Parkland, a school that I have spoken to, it's not in the congressional district that I'm privileged to serve. It's in Congressman Deutsch's district, but it's juxtaposed to the district that I serve, and many of the children over the course of the last few days that I've had an occasion to speak with at other schools other than Parkland are equally concerned. But so today, I'm sure we'll have a moment of silence. And it's a very challenging moment for me because I do agonize with those 17 persons that lost their lives and the ones that were injured, and the hundreds that are fearful, and the thousands that feel as they do regarding our lack of response as an institution. So I'm not certain what I'll do, but I do know this, that it is wrong for us to just have moments of silence and offer our thoughts and prayers and then do nothing. Thank you, Mr. Chairman.
Jim yields back his time. If I could respond to the gentleman just for a moment. He was most generous, not only in his favoritism towards what I did do, but also what I said. I would like to share with the gentleman, and I will do it by handing you a sheet of paper. In fact, I tried to myself address the special agent in charge of the Dallas division, the North Texas division of the FBI, and I asked him as a single member, because I'm not sure what this body will do. I gave my ideas to him and asked that the FBI designate this as one of the top 6 priorities that the FBI does do, and that they put it into one of those top criteria, that they follow up and have a designated group of people in Washington, D.C. with 24-hour phone access, that they make sure that all 59 field officers of the FBI have a direct person who would come into contact if it be 2 in the morning, that they're contacted immediately, that they be able to engage the behavioral unit of the FBI to figure out not only lessons learned, but also what is about the mental capacity so that people might be trained and learn about mental illness and be able to apply that properly for us to understand more about these people. I have done a series of these things which I felt like were in my own capacity, and so I really would like the gentleman to know I'm not just waiting on Congress. I don't know what we're going to do as a legislative body. What I do know is that I'm calling together on March the 9th all mayors, superintendents, and police chiefs that are in the 32nd Congressional District of Texas, and we're going to have a private meeting where we are going to try and discuss the thoughts and ideas about their best practices, their ideas about how to respond, and to make sure we're of one body, one mind, and idea, even though there's entirely different cities with sizes and scopes and differences, to try and view this with the same lens of public safety, campus security, and security for our children, up to and including where I'm going to ask every single superintendent to meet with every single principal and staff member of a school to make sure they know what the plans are and ideas, to meet with the students and tell them what their responsibilities are, and to meet with the parents to make sure that the parents, if they know that they called somebody and they did not see something happen that day, that they have another outlet. And that outlet might be the mayor's office or the superintendent, but that we have to get it right, because a call at 3 in the morning about a person could mean a shooting at 7 the next morning. There is no delay in time. So I am encouraging members of this committee, people that I've come into contact with, please have your own plan also. Please do what works locally and not just worry or wait for Congress to act. So that is my contribution to my own sanity and effort right now. I do intend to make sure that we will bring quickly, as soon as the areas of jurisdiction come together, whether it be Judiciary Committee, Homeland Security, or someone else. And I will make sure that we bring those ideas up here. But I do want you to know I appreciate the gentleman, and I will join with you in any thoughtful ideas that you have about how we might make this better, and then I know you'll work within this body also. Yes, sir. Yes, sir.
Everything that you said is particularly useful, but you didn't say the word gun. And something needs to be done about guns in this society. It is an epidemic, and it needs to be addressed. I appreciate everything that you said, and I assure you, the Florida delegation is meeting tomorrow specifically to do the same kind of things that you're talking about with reference to school safety. But I just can't abide the notion that we can't do anything about guns in this society. And I'm not suggesting that that's your position. Yes. But I notice when the talk is flush for us during a period of time, that we talk about mental health, we talk about school safety, all of that is a priority, just like the stuff here today. But my position is, today, we should have been dealing with measures about guns, as important as sex trafficking is, and that ought to be as much a priority as anything else. But I agree with Ms. Slaughter. Dodd-Frank, as controversial as it is for our people, is not killing people directly. It may be killing them indirectly, but it certainly isn't killing anybody directly. Anyway, I appreciate you, Mr. Chairman.
And in fairness, not to continue this, which it is, but I was trying to make sure that the most important thing I asked the Bureau in Dallas was, what's sitting in queue right now? Knowing that we had things in queue that might have been in Washington, and they said 0, and that gave me that opportunity. I'd also like to enter into the record what I believe is a letter, an article from the New York Times. Domestic abusers are barred from gun ownership, but often escape the law, and without objection, I'd like to know that record that just amplifies what Mrs. Slaughter may have been saying.
We knew we really need to change some laws. I mean, the notion that a doctor can't ask if there are guns in the home, they can ask about drugs and everything else. The fact that we don't allow any research, the fact that nobody can sue them. I mean, it seems to me that no matter what they ask, how far-reaching it is, how anathema it may be to other laws that we have, they get put right into law without any question. I think I know what we're going to do here. I think they're going to change the age at which you are able to get yourself an assault weapon. At least that's what I hear that the House is going to do. And let me tell you, that's not going to even come close. And that's really embarrassing, and I'm not sure that the people in the United States are going to be very happy about that. Since Las Vegas and this last shooting, we have gone from 55% of Americans not wanting assault weapons on the street to over 70%. I think the time is now, and I cannot begin to tell you how proud I am of those school children. First, I'm so impressed with how articulate they are, this extraordinary school district. But if those aren't going to be leaders, I don't think I'm able to recognize them. But they're not going to give up. They're not going to give up. And a lot of money's going in there, I know, to register them to vote. And that's where we're going to feel it next time around. So, but it's just high time. I can't believe that all these years that we've talked about this and worried about why. It's the same way I always ask why everybody wants to take health care away from poor people. Why do you want a 17-year-old, anyway, to have an assault weapon? Doctors say that those wounded people, or the dead came in, it was as though they had swallowed a bomb. Their organs are literally destroyed. They are ripped to pieces, which is why they never showed any of those children from Newtown. ever, because nobody could stand that. But that's the reason those guns were built, because they wanted to kill as many people as quickly as they could. But I will tell you, the notion that the United States of America would let them kill our children with those and not do anything, just I don't know how in the world we could ever live with our conscience. We do have them, I know that.
Well,
But no NRA, no lobbying firm, and we know that they are fronts for the gun manufacturers. We all know that. And every time they have one of these mass shootings, gun sales go sky high. So knowing that, I don't think anybody should have that kind of power over people who are sent here to do the best they can for the people of the United States. And if we keep turning our back on the fact that they are not ever safe, can we live with the fact that every day when our children go to school, we may never see them again? We didn't grow up in an America like that. I don't want the idea that those kids, I remember getting under our desk in case of bombs, but the idea that every day they have gun drills when they're 6 and 7 years old, because we won't do anything. We're the people who can do it. And I think we're the people who'd better. So let me yield back.
Joel, yield back.
Thank you.
Thank you very much.
And I apologize to all of you. I'm sorry.
Here's our guests, and they're a part of this discussion too, and I know they have an opinion. And I do appreciate you. Is there any other member of the committee that wishes to be heard? Okay. Thank you. Thank you for joining us. We know that you're engaged in this issue also. This bill was scheduled, and we're delighted that you're here. So we're going to move first to the gentlewoman who has spent literally 2 years or more trying to make this a major effort. And I remembered one of the first days that you began speaking about it, and I not only thanked you, but really was shocked and horrified to hear the facts of the case that are happening in our neighborhoods. The gentlewoman is recognized.
I thank you, Mr. Chairman. I thank the ranking member and the full committee of rules for the opportunity to testify on H.R. 1865, the Allow States and Victims to Fight Online Sex Trafficking Act, or FOSTA. This legislation has been born sadly out of necessity, but has been a labor of love since the very first time I was elected to Congress some 5+ years ago. The bill is a result of meetings with trafficking survivors across the country who have been victimized by the online sex trade and unable to access either justice or relief in our court systems. Tomorrow's consideration of the bill is an historic achievement, a long-awaited clarification from this Congress that the businesses that sell our children online can no longer do so with impunity. It is a clear statement that there are serious legal consequences for websites that actively profit from the exploitation of our most vulnerable. It is a wake-up call to America's judicial system, making clear that Section 230 of the Communications Decency Act does not provide immunity to websites that are actively engaged in modern-day slavery. FOSTA is a recommitment to Americans that Congress never intended to create a system that allows businesses to commit crimes online that they could not otherwise commit offline. And it is in many ways just a simple statement of the obvious. Congress does not believe and did not ever believe that rape was a prerequisite of a free and open internet. This bill is a promise to our state and local law enforcement and prosecutors. Congress is making it clear that we believe in and support their missions to protect our communities. And combined with the Walters Amendment, which reinstates victims-centered provisions from my original bill, this legislation is a guarantee of the fundamental rights of the most vulnerable members of our society. It is a message to the children and victims who have been robbed of their basic dignities that Congress hears them and is responding to the injustices that they have faced. It has not been an easy journey to get this to this point. to find middle ground with the tech industry, the victims' advocates, to incorporate the concerns of prosecutors, to move this bill through committee and to get both FOSTA and SESTA, the Walters Amendment, to the floor. So I am very grateful for the many, many people who joined my crusade to restore justice to the brave children, women, and men across our country who have been sold online. I am grateful to Chairman Goodlatte and his entire team and staff for going that extra mile in helping us include a strong new crime that will enable prosecutors to better target online trafficking and prostitution. I am grateful for the Energy and Commerce Committee and the House leadership and their willingness to prioritize this issue and piece of legislation. And I must give big thank you to the Majority Leader McCarthy, our Whip Scalise, and Speaker Ryan for leading the way in doing the right thing for Americans' children and victims. I'm grateful for Senators Portman and Blumenthal, Senators Cornyn and McCaskill for carrying SESTA on their shoulders and advocating for a solution that allows victims to access the civil remedies that they deserve. I am grateful for each and every one of our 176 co-sponsors, many of whom personally stopped me on the House floor to hear and express their concerns about the victims of online sex trafficking, especially Congresswoman Carolyn Maloney and my dear friend Congresswoman Joyce Beatty, who fought the good fight on the other side of the aisle for a truly bipartisan solution. I am also so thankful for my dedicated staff who have poured their hearts, their minds, and their lives into this fight in more ways than the public will ever know. FOSTA, combined with SESTA, will produce better civil justice for victims, more prosecutions of bad actor websites, more convictions, and more predators behind bars. Because of this package, fewer businesses will dare to enter the sex trade, and fewer victims will be sold into sex slavery. Last but most importantly, I am in awe and grateful for the contributions of survivors. Survivors in the fight to turn FOSTA and SESTA into law. It is heartbreaking to watch survivors struggle to piece together their lives all alone while a justice system shields the websites that sold them. That is why I introduced this bill, and that is why it must become law. Thanks to you, to our colleagues. When we vote for FOSTA and the Walters Amendment tomorrow, these survivors will know that they are not alone, and justice will no longer be out of reach. I thank you, Mr. Chairman, and I yield back.
Councilwoman Langer, thank you very much. The gentleman from the Judiciary Committee, Mr. Moreno.
Chairman Sessions, Ranking Member Slaughter, and members of the committee, thank you for the opportunity to appear before you today as you consider the rules for H.R. 865, the Allow States and Victims to Fight Online Sex Trafficking Act of 2017, also known as FOSTA. And before I go on, I would like to say that I'm very proud as a prosecutor. Several years ago, before I decided to run for Congress, the Middle District of Pennsylvania, when I was U.S. Attorney, we put one of the largest sex trafficking gangs away on the East Coast for years of torture that they were putting women and children through. Support this tremendously.
Thanks.
This important piece of legislation serves to safeguard our children from those who seek to harm them. The scourge of sex trafficking in the United States demands increased law enforcement attention. Trafficking has proliferated in recent years as gangs have discovered in these victims an easy business opportunity. They are products that can be sold over and over again and pose less of a risk than selling drugs, as the victims are often unwilling to testify against their traffickers. Exploitative website operators also see a business opportunity in this market and have purposely operated websites that enable these illicit transactions. FOSTA gives law enforcement the tools to go after the principal pimping and sex trafficking online marketplaces. It would prohibit any use or operation of an interactive computer service with the intent to facilitate or promote prostitution of another person. This effectively outlaws, except in jurisdictions where prostitution is legal, unfortunately, the operation of websites such as escort or adult services sites that openly allow the pimping of others for sexual services. FOSTA would not only allow law enforcement to reach self-identified escort websites, but also websites that seek to evade the prohibition by deliberately disguising such ads as dating or romance ads. This measure alone would have a huge preventative effect on sex trafficking by outlawing the explicit websites that serve today as the primary marketplace for trafficked victims, and by permitting such sites to be shut down without having to show that the prostitution services being offered are those of minors or coerced victims. Beyond this broad preventative provision, FOSTA creates an aggravated violation with a penalty of up to 25 years in prison where the person who intentionally uses or operates the website to facilitate the prostitution of another acts in reckless disregard of the fact that such conduct contributed to sex trafficking of a minor or coerced victim. Normally, it is difficult to prove that a third party who facilitates the pimping of others has actual knowledge that the person offered for prostitution is a minor or a victim of coercion. Under FOSTA, once a person chooses to facilitate prostitution through an interactive computer service, they are held accountable for any sex trafficking to which their acts contributed simply if they acted in reckless disregard that it was occurring. This allows the reckless disregard standard to be applied to the class of persons and entities most likely to be involved in facilitating sex trafficking. Finally, in addition to providing mandatory restitution to victims as part of the criminal sentencing, FOSTA also provides that anyone injured by an aggravated violation, that is, any minor or coerced victim of a violation, may bring a civil action for recovery of damages against the guilty party. Beyond this, FOSTA also amends the Communications Decency Act, or the CDA, to ensure vigorous criminal enforcement of sex trafficking laws at the state and local level. The CDA was landmark legislation passed in 1996 in which Congress framed the general policy that interactive service providers, including websites, should be immune from civil liability for offensive content posted by others as long as they play no role in creating or developing the content. The CDA also places limits on state criminal law and only permits states to bring criminal actions against information service providers, such as websites, where the state law is deemed consistent with the CDA. Notably, the CDA has no effect on federal criminal law. Unfortunately, bad actor websites such as Backpage have used the CDA as a shield in state criminal litigation. Courts have denied states the abilities to use state laws to prosecute bad actor websites, even where the state law is nearly identical to federal law, because the courts have reasoned the laws are inconsistent with the purpose of the CDA. This is clearly an absurd result. To remedy this issue, FOSTA also explicitly permits states that have laws that mirror federal sex trafficking law and the newly created prostitution law to prosecute them notwithstanding any provisions in the CDA. Such a change is necessary to assure that we are working with all hands on deck to dismantle these marketplaces and combat these horrific crimes. Thank you for allowing me to testify before you today, and I look forward to answering your questions.
Mr. Marino, thank you very much. The gentlewoman from Texas is now recognized.
Chairman, the ranking member, thank you so very much for your courtesies and the passion that you've already shown toward our children. Let me first of all thank Congresswoman Wagner for her years of service and dedication to an amazingly challenging and dastardly act that many people around the world and nation would point and say it's not here, it's somewhere else. Human trafficking, online trafficking, sex trafficking is right here in our backyard. And I thank her for her persistence and determination. As the ranking member of the subcommittee on criminal justice on judiciary, I'm very glad to embrace over the years this question of fighting human trafficking. In my own hometown, it is reported that the highest number of calls to the National Human Trafficking Hotline in Texas comes from Houston. And a study conducted by the University of Texas stated that there are more than 300,000 victims of human trafficking in Texas alone, including 79,000 minors. In the United States, 82% of sex trafficking, which obviously includes online, involves forcing girls and boys as young as 13 years old and younger into commercial sex acts, much of this online. This is a dastardly, devastating act. Interestingly enough, I held with Chairman McCall the first field hearing on human trafficking in the state of Texas just a few years ago as a member of the Homeland Security Committee, as we noted the violence of sex trafficking, went to a stash house physically where they were keeping these victims. And in fact, just last Monday, sat down with a room of sex trafficking, anti-sex trafficking advocates to listen to them, even before Congresswoman Wagner hearing that we had set this bill up for the floor. So I am grateful to be able to be here, and I wanted to make note of the church that hosted us, the Community of Faith, Bishop Dixon, but just to cite a story of a parent who had to secure his child with a payment of $50,000, a young woman who was lured from her home, lured from a party where she was trying to get a ride, and he had to secure her after a long period of time with $50,000 and $60,000 in rehabilitation. Not many families have that ability. So it is obvious that we're here for an important reason. But before I continue, I'd be remiss if I did not acknowledge the pain of last week with the Douglas High School, the beauty of these students in their response, but the sadness that they would have to respond. And to make mention, as we are sitting here today, I know the world, the nation is crying out for us to act on gun violence, and guns do kill. And I hope that we will see those kinds of, that kind of legislation, which I advocate and support, coming before the Rules Committee. But I want to speak now to the fact that Section 230 of the Communications Decency Act was unfortunately given a different interpretation by the First Circuit ruling in Doe v. Backpage. And so that interpretation that caused a protection or a armor for Backpage to shield the company from the victim's release or even being held accountable, this legislation was needed. Victims cannot and could not do this alone. I have a handwritten list of, a long list of additional sex trafficking, anti-sex trafficking organizations that I had the opportunity to meet with, even adding to the expanse. There's so many who are crying out for change. So I welcome this legislative package that would include the underlying bill and the amendment offered by Representative Walters of California for the following reasons. Representative Walters' amendment would clarify that Section 230 of the Communications Act does not limit federal civil causes of action based on conduct that constitutes a violation of the federal trafficking or state criminal prosecutions for conduct that would constitute a violation of the federal sex trafficking statute or the federal offenses newly created by H.R. 1865. It is wonderful that Sexter and Foster will be coming together. And I think it is important as well that we are able to look at this in a way that responds to the cry of the victim. I want to offer an amendment that I believe will help strengthen this legislation, and I'm delighted that if I can go back to the Walters Amendment, that the state's attorney generals now could bring federal civil actions against any individual who violates the federal sex trafficking statute on behalf of the residents of the state. That is a well-needed provision. Now, I support the First Amendment. None of us here deny the importance and cruciality of the First Amendment. I would imagine that all members of Congress are constitutionalists. But I also support the eradication of human and sex trafficking, and in this instance, online. So I've offered some amendments that would provide Congress with a measure of the effectiveness of the civil recovery and the mandatory restitution provisions by the underlying bill. My First Amendment requests a GAO study of the effectiveness of the new provisions enacted by H.R. 1865. In particular, the report would have the amounts of the damages awarded, the restitution amounts ordered, reports the amounts that are requested by the victims and the government on behalf of the victim, the nature and descriptions of the losses that are claimed, the justification for the amounts that are in fact to be paid. And I think the clarification would help us strengthen and move forward. And so I hope this will be made in order. Very gratified to have spoken to Congresswoman Wagner, who supports and has no problem with this particular amendment. I'm adding my Second Amendment would create a state-level civil cause of action for victims to aid in their efforts to hold all entities responsible that contribute to this reprehensible crime, which also is ensuring that there is a single national standard for asserting such actions. These amendments will not detract from nor usurp the spirit of the underlying bill. Sex trafficking is inconceivable, callous, and brutal crime that unquestionably deserves the nation's utmost attention. Might I just say personally, it is now 2018, looking forward to 2020, 20 years into the 21st century. Can this nation not eradicate the idea of sex trafficking, online trafficking, human trafficking? It is particularly difficult to see the victimization of very young that are sold or tricked into becoming victims of sex trafficking. If you walk the streets of some of our cities, you will see some of the children, teenagers, who really come to Houston because of the warmth. You will also see, as we know, one of my colleagues, Congresswoman Bass, works a lot on foster care. These children age out, they leave their homes, and they come, and Houston attracts them because of the warmth. As I indicated, it may be in other cities, but that is why we are sort of called the epicenter of human trafficking. Like my amendments, Representative Walters' amendments will hold accountable those providers that look the other way while knowingly allowing criminal activities to occur on their platform. Might I just say that these children are held violently, and I would imagine that some are held by perpetrators with guns to intimidate these children. They're starved sometimes. They're not treated well. They don't get good health care, and they're used over and over again because they're more of a financial, if you will, bounty than drugs. Drugs are consumed. These youngsters are used over and over again. As a society, we encourage an advanced market where a free flow of ideas benefits us all when exercised appropriately. Section 230 is significant in that it is vital to the growth of the internet, which plays an integral role in the daily lives of us all, not just in large conglomerates, but in small businesses and startups. Therefore, it is essential. But how do we hold accountable the true bad actors without trampling on the constitutional rights of users and providers that are good actors that may be swept in the wide net? I think that we have found this pathway. We have a direction from the courts, but we also have found that the tech community recognizes that they have to be good Samaritans, good actors, and that these children are too precious to leave them and others to leave them alone. And I recognize that the efforts made by all involved parties to include amendments and suggestions, and we're building this pathway. This is a building block. I'm looking forward to additional legislation that I hope to introduce that will continue to build on saving these victims. The victims and survivors are crying out for a change in the law. They're crying out for justice. They have tried to bring cases against the people, websites, and online servers who they believe contributed to their suffering and profited from their victimization, and that has been to no avail. Chairman Goodlatte and Ranking Member Nadler have made a valiant effort to create an offense to serve as a weapon against online sex trafficking, and Representative Walters has provided a federal civil cause of action for victims of online sex trafficking and allowed for state prosecutions of online sex trafficking while setting a national standard for those prosecutions, as I have offered for state civil causes of action. And Congresswoman Wagner and her team has been the anchor of moving this forward and staying the course, being determined to say that these victims, these babies, these youngsters, these women, these girls, these boys have to have a rescue. I think we're on the pathway for this rescue. All the questions raised can be difficult, but we can find solutions, and I believe that we're working toward those solutions as well. And I also ask consideration, as I indicated, for my amendments, the Jackson Lee amendments, in particular the support of the GAO study that will help everyone that I think, and that we all have come to a conclusion that will be very helpful in this matter. With that, I yield my time, and I thank the committee very much.
Ms. Jackson Lee, thank you very much. I'll defer my time to the gentlewoman from Wyoming. Gentlewoman's recognized.
Thank you very much, Mr. Chairman. I appreciate it. I also want to join in thanking Congresswoman Wagner for all of her work on this. I think it's a hugely important issue. And I also want to just say something about the discussion that was going on before I came in about the issue of guns. And I can tell you as a mother that what I think that we need to see is a situation in our schools where people know that if they're going to attempt to enter a school and do harm to our children, that they will face harm themselves. And I support what the President has said. I think we need to look at a situation in which we harden the security of our schools. And I think, frankly, that it is too much politicizing this issue for those who are advocating for gun control to be in a situation where you're making assertions about the reasons why those of us who support the Second Amendment do so. I support the Second Amendment because it's a crucial constitutional right. And people can make allegations about the NRA. I think it is wrong. I think it's unfair. I am a lifetime proud member of the NRA, as are most of my constituents. We believe in and understand the importance of the Second Amendment, and I think it's crucially important that we find ways to keep our kids safe, that we don't use this as a political issue, but that we think about what is really necessary. And in addition to making sure that our schools are secure and hardened targets, it is absolutely outrageous that the sheriff in Broward County is in a situation where he is day in and day out attacking those of us who support the Second Amendment, attacking the NRA, when 23 times reports were made to his agency, when reports were made to the Federal Bureau of Investigation and nothing was done about it. We cannot be in a situation where we've got law enforcement agencies and officials who are failing to keep our kids safe and failing to do the job. And rather than look at what we've got to do in order to fix that problem, we are instead politicizing this issue and casting aspersions. I think we can work together to find solutions, but the solution is absolutely not a solution that requires us to walk down a road here where we take steps that are unconstitutional and that will provide false comfort across the board. So again, our thoughts and prayers certainly do go out to those who were involved in this tragedy. I believe the prayers do matter. And I think it's very important for us to take steps that are effective and not to go down a path of politicizing this tragedy and make sure that it never happens again. And I think it's crucially important that we do everything we can on this particular issue in front of us and not act as though this issue is somehow unimportant because of the tragedy that occurred in Florida. And with that, I yield back.
Thank you very much. The gentleman from Georgia.
Thank you, Mr. Chairman. I didn't have any questions. Just wanted to express my thanks. Ms. Jackson Lee is always a worthy advocate for those causes that she believes in, and a tireless advocate. I'm grateful to her for that. Mr. Marino and I came in together. He doesn't just talk about keeping bullies in their place. He doesn't just talk about standing in that gap. He's made decade upon decade of his life dedicated to holding bad people accountable when they do bad things, and I'm grateful to him for that. And Ms. Wagner, you set an example for us, a difficult issue, heart-wrenching issue. We all want to get it right, but getting it right is hard. And you could have come in thinking your idea was the best, and only if folks decided to do it exactly your way could you partner with them to make a difference. And I would tell you, we wouldn't be sitting here today if that were your leadership style. Your leadership style has been to bring people together and to do what it takes to work with folks line by line by line, if necessary, to build a consensus. Because having good ideas is thoroughly worthless if you can't put those good ideas into practice. And I'm grateful to you for not giving up and giving us an opportunity to be here today. With that, Mr. Chairman, I yield back.
Gentleman yields back his time. Thank you very much. Gentlewoman from New York.
Thank you very much. Ms. Wagner, thank you very much for doing this bill. Do I understand that you're talking about the Walters Amendment, though, as being a part of it? You want that passed?
Yes, Ms. Slaughter,
Okay.
absolutely. That's a crucial piece of this legislation,
Right.
and it was originally a part of my original FOSTA legislation that was put forward. This has had multiple moving parts. I'm so pleased to watch it be married back up together, to add other good positive amendments to the legislation. This is going to be the toughest criminal legislation ever on online sex trafficking, while also securing the rights and to give some kind of justice to those victims that they so poorly
I
needed.
thank you so much for doing that. It was really wonderful. And I think with that addition of the Walters Amendment, that everybody on our side, I can't imagine anybody, Sheila, I hope I'm speaking for you as well, that
You are.
appreciate what you've done. And Mr. Marino, thank you for your work as a prosecutor. So there's the children victims of this. I've worked with it for a long time. You're starting off with sexual assault in the military, and it's a pretty terrible thing. But the fact that they got along by saying that the federal bill prohibited them from doing something they should have done a long time ago. Thank you. I'm very grateful to you and happy to support it.
Gentleman yields back his time. Thank you very much. Gentleman from Georgia. Gentleman yields back his time. Thank you very much. Gentleman from Florida, Judge Hastings. Gentleman does not seek time. Thank you very much. The gentleman from Alabama. I have no question. Gentleman does not seek time. The gentleman from Washington.
Thank you, Mr. Chairman. I just wanted to echo the comments of my colleagues up here to express appreciation to you addressing this serious issue. It's not just in the big cities of this country where this is a problem. I represent a rural area, and human trafficking and sex trafficking is a big problem in small communities as well. So I want to acknowledge your hard work in helping to solve this issue and give victims some additional rights that they are seemingly forgotten many times. I did have just one detailed question that Mr. Marino, you were addressing in your comments. I think I heard you say something that your sentence ended with, except where prostitution is legal. So that, am I to take from that utilizing these websites is okay if you're in a jurisdiction where it's not illegal to engage in prostitution?
No, not at all.
Okay.
I think I finished that sentence with, unfortunately, because of my opposition to prostitution, legal or otherwise. No, it is not. And the comment that I was trying to get across was just related to where prostitution is legal. And I said, unfortunately. But no, this doesn't prevent. As my legal eagle just informed me, it isn't an affirmative defense if it's legalized in a state or a certain jurisdiction within a state. So the person has the opportunity to come up and use whatever they may use who are running things, that it was legal or legitimate. It doesn't mean that this law is not going to apply.
And if I may, there is no jurisdiction where promotion of prostitution is legal. And certainly what the new crime does is deals directly with criminalizing both promotion or facilitation of prostitution and reckless disregard of sex trafficking. So.
Okay.
What we're doing is this. We're giving prosecutors, and we've dealt with district's attorney, prosecutors, as Ms. Jackson-Lee has talked about, 50 attorneys general, others in law enforcement. that we're trying to give them as many resources as they possibly can have to get criminal prosecutions, which have been very difficult when it comes to online sex trafficking. So whether it is using our current sex trafficking statutes and laws and legislation, or whether it's also using those that are in the prostitution realm too, we want to give them every opportunity to prosecute and then ultimately give justice to our victims.
Okay, well, appreciate that. Mr. Marino, further comment?
Just one last thought. Again, you made it very clear, but I want to emphasize, where prostitution is legalized, it doesn't mean that a person is not coerced into that.
Correct.
So an individual is coerced into a state where it is legalized can also bring, law enforcement can also bring criminal charges against someone.
That's very helpful.
Improve.
Very helpful. Well, thank you for that. I just want to make sure there wasn't some loophole there that we were skipping over. So
we've been dealing with loopholes and, for 2.5 years on this legislation, and I'm just pleased to be able to bring everyone together to move this package forward. And I do believe that it is landmark legislation that is going to clarify congressional intent. We never meant, and back in 1996, when the Communications Decency Act was passed by Congress, by Senator Exxon, a Democrat in the Senate, his very words were, he never meant for the internet to be a red light district. And this issue of sex trafficking, and particularly how it's moved from the streets to the internet, is indeed hiding in plain sight, and is the victims that have fallen prey to this, and not just the Backpage.coms of the world, but the hundreds of other nefarious websites that are selling our children, our women, our young boys online, must stop. Congress must make its intent known, and we must give the strongest tools possible to prosecutors while making sure that our victims can receive the justice that they need. And that's what the entire package of this legislation does.
Oh, thank you.
If I may,
oh, certainly.
If I may, and I'm sorry, my back is toward you. One of the stronger elements is to give another layer of eyes, which are the State Attorney General's eyes, to this issue. They know their state, they know the bad actors, and they know the impact on the children in their state. So we've now expanded the reach. And I think the element of coercing and victimization is very important, which I might add was the intent of the Jackson-Lee Amendment on the study, to ensure the effectiveness as we go forward on how we're doing in eliminating the dastardliness of online sex trafficking, and I'd like to think human trafficking as well. But giving those eyes to the state attorney generals then gives another layer to pierce into each state's bad actors.
Okay. Thank you, Ms. Lee. Well, again, you're all commended to be for your hard work on this. I look forward to voting for it on the floor, and thank you, Mr. Chairman. No further questions.
Gentleman yields back time. I'm going to yield myself now defer to myself. I want to thank at this time the gentleman, Mr. Buck, who has taken a great deal of time, not only as a former district attorney who saw these sorts of abuses, but also his wisdom as he was very thoughtful, I believe, during the week to make sure that no one would be immune from prosecution or could hide from law enforcement. No one would be immune, regardless of their status, that he views, I view, I think all of us view, that this is such a heinous abuse of not just people, but in particular of people who are children and could not perhaps defend themselves. And I want to take my minute to say, Ann, thank you. I think that your devotion to this entire process, your hard work, was aided by, and I felt like the good thinking that included Mr. Buck to satisfy himself that what your law does is there will be no crack in this, no place where there might be a seam, and that Mr. Buck did that. I want to thank the gentleman from Colorado for his not only hard work but also ideas, and so I want to thank both of you at this time for caring about this. Mr. Buck from a position of a district attorney, a person who's in Colorado, a parent, seeing these things, and you as a parent, a person from Missouri, Clayton, Missouri, who understood well what this issue was. And so I want to thank both of you. Gentleman from Colorado.
Well, thank you, Mr. Chairman, for your kind comments, and thank Ms. Wagner for her great bill, and Mr. Marino and Ms. Jackson Lee, my colleagues on the Judiciary Committee, for their great work. And I yield back.
Gentleman yields back his time. Thank you very much. I want to thank each of you for taking time to be with us today. Is there any other member that seek time? Seeing none, I want to thank this panel for their opportunity. Without objection, as I had mentioned earlier, anything you brought in writing, even if it's handwritten, Ms. Jackson Lee, our awesome stenographer, will be in receipt of that, allowing them to complete the transactions that took place here today. Thank you very much.
Chairman, may I?
Yes, ma'am.
The amendment, will that be, we can get that in?
Well, we're going to make a decision here shortly. And I heard you say that.
I believe it's important.
I heard you say that you would anticipate you'd be in full support of.
Full support.
As am I, as am I.
Of
I
what
can
Mindy's
assure the
done
ranking
here.
member.
All right.
Good. Thank you very. Good question.
Okay.
Well, that will certainly be considered, and you showed up and did well, Ms. Jackson Lee. So I appreciate you taking time to do that. I thank this panel. We'll now call up our second panel. Is there anyone else that seek to give testimony to H.R. 1865? Seeing none, this now closes the hearing portion of 1865. We'll now open up to H.R. 4296 and H.R. 4607. We would welcome to the committee the gentlewoman from Los Angeles and the gentleman from the state of Missouri. And I want to thank both of you, Mr. Luke DeMeyer, for taking time to be here today, and certainly Ms. Maxine Waters. Thank you for joining us today. Your testimony here before the committee is important. We appreciate what you bring to the committee. Without objection, anything you brought in writing will be entered to the record today. The gentleman from Missouri is recognized.
Thank you, Mr. Chairman. Mr. Chairman, Chairman Sessions, Ranking Member Slaughter, and members of the committee, thank you for the opportunity to appear before you to testify on behalf of two bipartisan bills in the Financial Services Committee. H.R. 4296, a bill that addresses difficulties with operational capital requirements imposed on financial institutions, and H.R. 4607, the Comprehensive Regulatory Relief Act. Both these bills are common sense reforms to regulations that will improve the efficiency of our financial system. Legislation H.R. 4296 will replace misguided capital standards imposed by international standard setters at the Basel Committee. The Basel Committee requires U.S. institutions to hold excessive capital based on a look-back approach.
A little gas goes a long way, doesn't it?
We don't need to go back over that other part. We'll just keep going. How's that?
There you go.
The Basel Committee requires the U.S. institutions to hold excessive capital based on a look-back approach of an operations or organization's risks, previous earnings, and other provisions that provide no indication of future risks. The methodology employed by this international body has forced our banks to hold hundreds of billions of dollars in reserve rather than putting the money to work in the form of loans and investments. Let me say that again, Mr. Chairman. Hundreds of billions of dollars is currently sitting in banks across the country not being utilized to fund mortgage loans, car loans, and other day-to-day financing demanded by the American consumer. I recognize the importance of our nation's financial institutions to hold capital in the event of a future crisis or distress, and H.R. 4296 maintains those capital requirements. What it does is amend the method by which reserve capital is calculated by focusing standards based on an organization's current business activities. This approach offers a better assessment of the amount of capital that should be withheld or should be held to withstand any future crisis. The international regulators' defective approach has quarantined vast amounts of capital and hindered our institutions' ability to sufficiently supply the U.S. credit markets. The methods-based approach proposed by H.R. 4296 properly calibrates operational capital requirements. It maintains strong and healthy financial institutions while unshackling billions of dollars. The second bill provides another opportunity to advance a more practical approach to regulation. H.R. 4602, the Comprehensive Regulatory Review Act, sponsored by Mr. Loudermilk of Georgia, offers a holistic approach to U.S. prudential financial regulation. This bill requires all financial regulators, including the CFPB and National Credit Union Administration, to participate in the Economic Growth and Regulatory Paperwork Reduction Act, AGRIPA, Comprehensive Review of Rules and Regulations.
The purpose of the review is to ensure that regulation is not overly burdensome, duplicative, or outdated while maintaining standards to promote safety and soundness. Additionally, H.R. 4607 requires the agencies to meet every 7 years for a comprehensive regulatory evaluation as opposed to the 10-year cycle currently in statute. Mr. Chairman, I'm hard-pressed to think of a less controversial bill than this one, requiring regulators to review the impact of their actions in a transparent and consistent manner on a more frequent basis is simple, straightforward, and non-controversial. It's a great way to improve efficiency in the current regulatory framework. Mr. Chairman, a healthy financial system that enhances economic freedom can only exist if we have a healthy and fair regulatory system. H.R. 4296 and H.R. 4607 have garnered bipartisan support because they are practical solutions that will properly guide supervisors to enforce more effective regulation. The result of these modest bills will be the promotion of a healthy, vibrant, and open economy that works for the American people. Appreciate the committee's consideration of these initiatives today, and happy to take any questions.
Mr. Lukemeyer, thank you very much. Job well done, sir. Gentlewoman from Los Angeles, recognized.
Thank you very much, Mr. Chairman and Ranking Member Slaughter, and committee members for allowing me to testify on H.R. 4607 and H.R. 4296. I'll take 4296 because my colleague started with that one. This would place new conditions on how regulators implement a specific capital requirement relating to operational risk. Operational risk capital is required to be held by a dozen or so of our largest internationally active megabanks, and it relates to operational risk such as legal liability and operational breakdowns of these megabanks, which we have seen too many examples of. These operational failures include, for example, J.P. Morgan's London Well trades and Wells Fargo's long list of violations that have ripped off millions of consumers, including those harmed by their fraudulent account scandal. So the megabanks on Wall Street are pushing for changes to this capital requirement and prefer rules that downplay, if not outright ignore, their recent and extensive operational failures that, in addition to causing losses for the megabanks, cause a lot of damage for consumers and the economy. I'm also concerned this framework could diminish instead of strengthen an incentive for megabanks to maintain stronger internal controls and risk management systems. This is especially concerning as we know that these banks now see the more than $160 billion in fines they have been assessed by regulators as simply the cost of doing business. The nonpartisan Congressional Budget Office has also weighed in on the risk of this bill. CBO has estimated that H.R. 4296 would lower capital requirements for the nation's largest banks, increasing their risk of failure in the future. And although I understand that there's an amendment to raid the Federal Reserve surplus account to cover the additional spending required by this bill, I would note that when a bank fails, the remaining banks, including our nation's community banks, will have to pay for any losses covered by the taxpayer. Even the Basel Committee, which several of President Trump's regulatory appointees now serve on, agreed in December when they finalized Basel III reforms, writing, quote, banks which have experienced greater operational risk loss historically are assumed to be more likely to experience operational risk losses in the future, quote unquote. So it makes no sense to have a forward-looking assessment that de-emphasizes a megabank's past operational risk losses in setting these capital requirements as H.R. 4296 proposes. Mr. Chairman and Ranking Member Slaughter, bank profits reached an all-time record high in 2016, and business lending is up 75% since 2010. All this happened while U.S. banks added more than $700 billion in capital to absorb potential losses. So despite Republicans' Chicken Little arguments about the dire consequences of the Dodd-Frank Act and related regulatory reforms, I think the data speak for themselves. Banks are making more money than ever, but apparently that's not enough. So I'm here again today appealing for all of us to continue to uphold common sense, safeguards for consumers and the broader economy, instead of pushing a nonstop parade of Wall Street giveaways. Thank you again. And of course, I look forward to answering your questions. But let me now take up the other bill that we're here for today. That is H.R. 4607, the Comprehensive Regulatory Review Act, and of course, the 4296 that I just took up, a bill to relax operational risk capital requirements for banks. As you can likely tell from the title of these bills, they are deregulatory measures, both of them, that would benefit the big banks, like many of the other bills that have been rushed through the Financial Services Committee with little or no time to give them the true consideration that they really deserve. First, let me talk about, well, secondly, let me talk about 4607. There is no doubt that this bill would constrain the good work of the Consumer Financial Protection Bureau by saddling the agency with redundant requirements and potentially favoring the banking industry over carrying out its statutory mission. The Economic Growth and Regulatory Paperwork Reduction Act, or EGRIPRA, requires the Federal Reserve Board, Federal Deposit Insurance Corporation, and Office of the Comptroller of the Currency to conduct a review not less frequently than every 10 years to identify outdated or otherwise unnecessary regulatory requirements imposed on insured depository institutions. This bill would amend EGRIPRA review to include the Consumer Bureau and the National Credit Union Administration, increase the frequency of the review from at least once every 10 years to at least once every 7 years, and add a mandate to subsequently tailor regulations to limit the cost and burdens on regulated entities and covered persons after the review. Now, I agree that there is justification for having NCUA participate in EGRIPRA process since the NCUA regulates insured depository institutions like the other federal banking regulators that are currently subject to it. And NCUA has voluntarily complied with EGRIPRA in the most recent March 2017 EGRIPRA report. That being said, the Consumer Bureau is already required to review its significant rules, assess their effectiveness, and publish a report on its review no later than 5 years after the rules or orders take place. Because of this existing statutory mandate and the Consumer Bureau's unique role as a consumer protection agency, it is duplicative and unduly burdensome to expand EGRIPRA review and to subject the Consumer Bureau to it. I also remain concerned that the bill would require the banking regulators to conduct a so-called comprehensive review that would actually revise the EGRIPRA process to have them primarily consider the impact, cost, liability risk, and other burdens to industry stakeholders. These considerations, as well as the underlying review criteria, would call on the Consumer Bureau and other agencies to tailor their rules based on an unbalanced review that complicates costs without due consideration of the benefits to the public or consumers, and this would result in an unfair and misleading analysis. This bill would make the banking regulators focus on deregulation instead of creating a robust process to identify regulatory gaps or deficiencies that may harm consumers, undermine the safety and soundness of our financial system, or jeopardize the country's financial stability. And so, with that, I'm opposed to these bills.
Thank you very much. We
You're
appreciate
back.
you taking time not only to
Thank
be
you.
with us, but to give us your expert opinion. Mr. Luke Meyer, I think this is a matter that economists have debated a long time, and we see play out in our economy on a regular basis. And that is capital requirements that are so high that the institutions that have the money can't lend the money. And I heard you say that you believe that there's a balance there, a balance in the marketplace that would take place between necessarily a lender and a borrower, and that you would like to see this capital requirement lowered really to meet the needs of consumers in a time when when not only is our economy trying to grow, but we're really trying to encourage people not just to get houses, but to go to work and have that lifestyle. The American dream is what we call it in Dallas, Texas. The American dream, where they can put their family together, they can put their job together, they can go and know that they've got a bank that they can, or credit union, that they can take a loan from and be able to be successful in that. Go to work every day, because I think it creates good behavior. And to do those things, what am I missing?
Well, I think you've hit it on the head, Mr. Chairman. I think, one of the, if we take a look at the reason the banks are, that this bill is even here, is that we have a Basel committee that's over in Europe. This tries to put out rules and regulations that transcend all of the regulations across the world. And so we allowed that to be imposed on our banks. They had 3 separate standards by which they wanted to do this. They've already taken one off the table and redone another one. They know that they didn't get this rule right. And so what we're trying to do here is make sure this rule is right for our banks, because, as you said, what it's doing is tying up capital. What we need to be doing is looking forward. Don't look backward with regards to how you losses. For instance, let's say that you have 2 institutions block apart. Both of them have the same kind of products. Both of them have losses on those products, so that one of them gets rid of it, the other one doesn't. So in other words, this capital requirement that the regulators are going to look at is going to say, well, they're going to continue, because of looking backwards, have the same capital requirements for both banks, where if you realize that one got rid of that product, the risk is no longer there for this problem to exist. Therefore, they shouldn't have any capital tied up as a result of that. The fairness of this is obvious. I mean, one bank got rid of the product, the other one didn't, yet the way that the examiners will treat it is the same. That doesn't work like that. I mean, it's a fairness issue. It's a way of looking forward. I was a former bank regulator. I can tell you that they need to be looking at how things are today. Look at the business model of the banks today, so that you understand going forward, have they made the changes to mitigate those losses that they've had? Are they in a position to where they're looking at trying to redo their business model so it can be enhanced? That's part of the regulator's job. And this bill takes nothing away from the regulators. A lot of folks will say, oh, all of a sudden the banks can no longer be regulated because the regulators have no ability to do this. No, it doesn't do that. If you have a bank that still has problems, or you have a bank that has a business model that is concerning, the regulator still could step in and force the bank to have additional capital. It takes nothing away from the regulators other than to say, take into consideration the business model going forward. Don't look backward at things that may not be important.
Well, it makes sense to me. This capital requirements has a lot to do with whether you can get a loan or not just the entity that wants to give a loan.
And those costs are passed on to the consumers.
Absolutely. Dr. Burgess? Dr. Burgess does not seek time. The gentlewoman from New York. Judge Hastings, do you seek time?
Briefly, Mr. Chairman. Ms. Waters, has the committee heard testimony from outside experts on the impact of this particular a bill, or on the majority of the deregulatory bills that have come through financial services?
I didn't hear the first part of your question, except...
I'll repeat it for you.
Would you please?
I just want to know whether or not you are following regular order, and are you hearing from outside experts with reference to the impact of these measures?
Yes, we are, and I think that the consensus basically is that we cannot forget the London Well, as I alluded to, and decisions that can be made by these major international banks, and that we're looking at the risk that can be created, the operational risk that can be created by these major banks, and not forgetting what has happened to us, I guess, around 2008. And for anyone to say that they do not support capital requirements that will ensure that these banks do not, take the kind of risk that they can afford to pay for. If they don't have the capital, then where's it going to come from? And so we're talking about operational risks that we haven't had experiences with, we know about. And we're simply saying, and the consensus basically is, that they really should have the capital in these international big banks that would ensure that they can pay for the risk that they incur.
All right, thank you. Mr. Lukemire, you were going to
Yeah,
say something. I would just add to that I don't disagree that we need to have capital to protect us against losses. I think that is, having been in, as a regulator and been in the business for 30 years, I'm one of the guys that would say you need as much capital as you can get. But you reach a point where you have to be practical as well. It costs money to hold capital. It costs money to the consumer to hold capital. And let's look at the business model of the entity. Let's look at the past losses. Let's look forward to how they mitigate those losses, and then sit down. And the regulators should be doing that. That's their job, is to recognize risk, to model that risk, and make sure that they have their requirements on those banks where it is not a cumbersome and expensive process for them to hold that capital, but whether they fine-tune that level. If the bank wants to hold more, that's their business, but they need to make sure that level is a minimum to where they have all those risks covered. So I don't disagree to a point with what the ranking member is saying, but I think you have to remember that the business model dictates what's going on. Past losses can indicate future losses. Then again, if you change your business model, it also it changes your risk model as well. Thank you very much.
Judge Hastings, thank you very much. In addition to the testimony that's been given, Judge Hastings, I would draw us to the report that was provided to us. H.R. 4296, the Financial Services Committee held hearings on April 26, 2017, and April 28, 2017. In addition,
it was also part of the Choice Act, which passed the entire House.
Yes, sir. Yes, sir. So that was contained within here. The gentleman from Georgia. Gentleman does not seek time. Gentleman from Colorado does not seek time. Gentleman from Windsor, Colorado. Gentleman does not seek time. I want to thank both of you for taking time to be here today. I think these are tremendously important issues and ideas, capital requirements and lowering requirements to get the right balance. And we're very thankful that both of you took time. We're thankful to the gentleman for the bill and the time today, and I want to thank both of you very much.
Thank you, Mr. Chairman.
Is there any other member that would seek to give testimony? Excuse me, sir?
Thank you very much.
Yes, sir. If you'll please remember that we have the awesome stenographer here who would like to receive anything you brought in writing. I'm sure the gentlewoman, your parliamentarian, will make sure that the awesome stenographer receives that. Is there any other member that seek time on H.R. 4296 or H.R. 4607? Seeing none, this now closes the hearing portion of both of those, and the chairman will now be in receipt of a motion from the distinguished gentleman from Louisville, Texas, Dr. Michael Burgess.
Mr. Chairman, I move the committee grant H.R. 4296, a bill to place requirements on operational risk capital requirements for banking organizations established by an appropriate federal banking agency, a closed rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-60, modified by the amendment printed in Part A of the Rules Committee report, shall be considered as adopted, and the bill, as amended, shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 4607, the Comprehensive Regulatory Review Act, under a closed rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and the ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 115-61, modified by the amendment printed in Part B of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
Thank you very much. I appreciate the gentleman for bringing forth. We, as you now understand, will have two rules. This was rule number one. This was rule number one covering H.R. 4296, H.R. 4607. You've now heard the motion from the distinguished gentleman from Louisville, Texas. Is there amendment or discussion on that? Seeing none, the vote will now be on the motion from the distinguished gentleman from Louisville, Texas. Those in favor signify by saying aye. Aye. Those opposed, no. No. The ayes have it. The ayes have it. Gentlewoman would like a roll call vote. Clerk will poll the committee.
Mr. Cole. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mr. Collins. Mr. Collins, aye. Mr. Byrne. Mr. Byrne, aye. Mr. Newhouse. Aye. Mr. Newhouse, aye. Mr. Buck. Aye. Mr. Buck, aye. Ms. Cheney. Ms. Cheney, aye. Ms. Slaughter. No. Ms. Slaughter, no. Mr. McGovern. Mr. Hastings. No. Mr. Hastings, no. Mr. Polis. No. Mr. Polis, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 3 nays.
Motion is agreed to as agreed to. Accordingly, is there further amendment or discussion? Seeing none, the vote, this will be handled by the gentleman from Windsor, Colorado, Mr. Buck.
And Mr. McGovern.
And Mr. McGovern will be handling this for the minority. Chair, now being in receipt of the second rule, the gentleman from Louisville, Texas is recognized.
Thank you, Mr. Chairman. I move the committee grant H.R. 1865, the Allow States and Victims to Fight Online Sex Trafficking Act of 2017, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes in order as original text for the purpose of amendment, the amendment in the nature of a substitute recommended by the Committee on the Judiciary now printed in the bill and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for the division of the question. The rule waives all points of order against the amendments printed in the report. Finally, the rule provides one motion to recommit with or without instructions.
You've now heard the motion from the distinguished gentleman from Louisville, Texas, H.R. 1865. Is there amendment or discussion to that? Seeing none, the vote will now be on the motion from the gentleman from Louisville, Texas. Those in favor signify by saying aye. Aye. Those opposed, no. No. The ayes have it. The ayes have it. Accordingly, the gentleman from Georgia, excuse me just a moment, please.
Oh, I'm sorry. Okay, we're fine.
Okay. So I'm going to go back and say the motion passes. Accordingly, the gentleman from Georgia, the gentleman from Judiciary Committee, Mr. Collins, will be handling this for Republicans. Ms. Slaughter will be handling this for Democrats. So let's see, Judge Hastings, you now ask the question. We do not have any other meetings scheduled for this week. As you know, the committee will be following the requirements of the House, whereby Dr. Graham will be laying in state, and so the decision's been made that we will postpone those further week. I want to thank the Rules Committee and its members for their time today. Thank you very much. We're now completed our work for the week.
I hear I missed an interesting one today.